Hi, I'm Erin Nielson from Wilshans, Cosentino, and Nobbins. I'm a family law attorney, and I'm here today talking with Shannon Vasconcelos, who is a college finance consultant with Bright Horizons College Coach. Thanks for being with me, Shannon.
It's
Um,
my pleasure, Erin.
so I asked Shannon to come and talk to me today because issues around applying for financial aid come up a lot with the clients that I'm working with. Shannon, it comes up sort of in two different scenarios. One, at the time that people are getting divorced and they are negotiating the terms of an original separation agreement. And then it comes up again later on when it's time for the kids to actually go to college and somebody has to really pay for it. So I'm hoping that you can shed some light on some of the questions that come up.
I hope so
Um,
too.
so kind of initially, when do you think is the right time for any family to start thinking about planning for financial aid?
It's never too early, honestly. As soon as that child is born, I would love for families to start saving for college at that point, anticipating that great big cost that might be 18 years in the future. So really, as soon as possible, I would love for families to start planning for college. And I do talk to families that do have newborn babies to get them on a college savings plan right from the beginning. But certainly once the student is in high school and they really start realistically thinking about college and looking at different colleges, trying to decide what they want in a college, the finances should come into the discussion right from the beginning so that everybody is on the same page, so they all know what kind of college costs are reasonable for that family and they can plan accordingly. There's certainly strategies you can employ applying to different kinds of schools at different price points or that require different financial aid forms to or where the student is a standout student or not that might make college more or less affordable. So certainly once the student is in high school and starts thinking about college, families should be talking about the cost of college and planning for it. Definitely by sophomore year of high school, particularly for divorced families, there may be some financial moves that families can make to make the financial aid process go more smoothly and more beneficially for them.
Okay. So when it comes to actually applying for financial aid, as I understand it, there are two different forms that families might be asked to fill out, the FAFSA or the CSS. Can you talk a little bit about those two?
That's right. Yeah, the FAFSA is the main financial aid application that was designed by the U.S. Department of Education. Every single college in the U.S. requires the FAFSA form. And then there are about 200 almost entirely private colleges that don't think the FAFSA provides them with enough information and require this additional form called the CSS or the profile. The CSS profile is the full name, where it digs a little bit deeper into the family's financial situation. So every college is going to ask for at least the FAFSA. About 200 will ask for that additional form, the profile. For divorced families in particular, the big difference between the two forms is that the FAFSA only requires information from what they call the custodial parent, and that actually doesn't matter what any actual custody agreement says. And for FAFSA purposes, the custodial parent is the parent who the student lives with greater than 50% of the time. Again, regardless of what any custody agreement says. If the student lives with each parent exactly equally, the tiebreaker factor is what parent provides greater financial support. That is the custodial parent for FAFSA purposes. The non-custodial parent is at least up front, invisible on the FAFSA. I think we'll talk a little bit more about that later. Their finances are invisible on the FAFSA. But at the schools that require the CSS profile, most of them require both custodial and non-custodial parent information. So you can see for divorced families, they could see vastly different financial aid offers depending on whether their child is applying to a FAFSA only school that just looks at the custodial parents' finances. And by the way, any step parents in the household, it's the entire custodial household, as opposed to if the student is applying to CSS profile schools that are going to look at both households information, both parents, potentially any step parents, and everyone's finances are getting considered at a profile school. So for families where that's going to make a big difference, where the non-custodial parent may make significantly more income than the custodial parent, and it's going to make a big difference to financial aid, they may want to focus their college search more on FAFSA only schools that are not going to look at the custodial parent.
Okay, so that's one great strategy. Let's talk again. You mentioned step parents for a moment there, and I want to go back to that. So on the FAFSA, step parents are included or not included?
They are. If it's the step parent in that custodial household, the person that is married to the custodial parent, their finances are in fact looked at on the FAFSA. So it is the income and assets of that entire custodial household, which could be the parent, the biological parent, or the adoptive parent, plus the step parent, whoever they're married to. That is the case on the FAFSA.
Okay, but if they're cohabiting and not married, the second income in that household is not included?
That is correct. At a FAFSA only school, that second income is not included. So it's definitely something for parents considering remarriage to think about. Introducing another income to the financial aid equation can make a big difference in financial aid eligibility. And I used to see it all the time when I was working in a financial aid office, and a student would I used to work at Boston University and Tufts University, and students might come in as a freshman with a great financial aid package, and then during freshman year their custodial parent gets remarried, and all of a sudden all of that aid disappears for future years, because now if step parent has a great big income, that is now feeding into the financial aid calculations. So those remarriage decisions for parents of college age students, they really have to think carefully and understand the financial aid implications.
Wow. And I guess from a family law perspective, that might trigger the sort of change that might trigger another modification as between the parents, because it would significantly change the amount of that each parent was expected to contribute to college. So you might also find yourself with more litigation in that scenario. So
yes, so lots of difficulties. Yeah.
An important strategy to keep in the back of your mind then, if you're find yourself in that situation. What about child support? How is that treated on the FAFSA?
Child support is looked at as untaxed income of the parent. So the parent, the custodial parent on the FAFSA is reporting their income. The biggest number that generally appears there is their adjusted gross income. That's the biggest number, typically feeding into the financial aid calculations. But then the FAFSA also asks about a number of forms of untaxed income that the parent may have received, and included in the list of various forms of untaxed income that they ask about is in fact child support. So child support does inflate the custodial parent's income for financial aid purposes. One thing that sometimes comes up in my conversations is if that child support is going to end at some point while the child is in college, it's something to bring up to the financial aid office that, yes, you're reporting income from a couple years back on your FAFSA, and you may have received child support then, but if that amount is going to decrease or disappear when the child is actually enrolled in college, that's something to bring up to the financial aid office. And they can take that into account, remove potentially the child support from the calculations if it's not going to be received in future years.
Right. Oh, that's an important thing then for Massachusetts families to keep in mind, because currently there is a presumptive reduction in child support at the time that children go to college. So there's pretty much always going to be that change. What percentage of income of custodial parent income is considered available for paying for college?
Yeah, the financial aid calculations are fairly complicated because a lot of different things are entering into the equation. But when it comes down to it, I would say if you needed to ballpark it, you might expect the colleges to expect that custodial parent to contribute about a quarter of their income, somewhere 20 to 30%. The financial aid formula is very focused on income, very harsh on income. So I would ballpark it at about a quarter of family income is expected to be contributed to college.
What about an asset like a 529?
Parental assets are assessed much more gently in the financial aid formula. Again, it can vary, but typically about 5% of parental assets. And 529s, college savings plans, for folks who aren't familiar, are looked at no differently than any other parental asset, any other money that the custodial parent has in a checking account, savings account, investment account. 529s are looked at exactly the same. They're considered because or whoever owns the 529, it is their asset. And if it's the custodial parent who owns the 529, assessed at about a 5% rate. So the formula definitely weighs much more harshly on income than it does on assets. Assets have a very gentle treatment. So I always encourage families to save as much as you can for college. Sometimes families will think I shouldn't save, I shouldn't put money in a 529 because it will cost me financial aid. Costs you very little. Whatever amount you have in that 529 will help you pay for college much more than the small loss of financial aid will hurt you.
And I guess for some families, then it might make sense if it could be agreed to start sort of funneling some of the child support through a 529, and in that way, it would have less of an impact on financial aid, if I'm understanding that correctly. So as income, it will have a greater impact than it would if it were in a 529.
That's correct, right? So yeah, you may want to sort of front load some of those support payments into a 529 because as an asset, it is assessed pretty gently by the financial aid formula.
Interesting.
Yeah.
Okay. So what is, I guess I would say, like the look back period, if you wanted to start doing some of these things, like shifting around a custodial arrangement or shifting around the way you pay child support, how soon do you need to do that?
Right, so the financial aid applications look at your income from 2 years prior to the year you're applying for aid for. So just to give an example, if you are a high school senior in 2020, you're going to be likely filling out your FAFSA in the fall of 2020. Starting college in 2021, if you're going to start college in 2021, they are going to look at your 2019 income on that first financial aid application. So it's 2 years prior to the year you're applying for aid for. You do have to reapply for financial aid each of the 4 years of college. So eventually there will be 4 years of income that the financial aid applications look at. But they tend to run, to make it a little clearer, they will run January 1st of sophomore year of high school through January 1st of sophomore year of college. Those will be the 4 years of income that are assessed eventually throughout the college career.
Okay. One thing we haven't talked about yet is student income, and how that's defined and how that impacts financial aid.
Yes, and this is where timing becomes very critical, particularly for divorced families where there is a custodial and a non-custodial parent for financial aid purposes. So student income is assessed very harshly by the financial aid formula after a basic, what they call income protection allowance. Students are currently allowed to earn or receive as income per year about $7,000. That amount is invisible for financial aid purposes, and that's meant to allow a kid to have a summer job, after school job, without it harming them on financial aid applications. But after that $7,000 allowance, any remaining student income is assessed at 50% So for every dollar they earn beyond $7,000, they lose 50 cents of financial aid eligibility. It is the harshest assessment rate in the whole financial aid formula, that student income. Why this matters particularly for divorced families is there is sort of a little nasty question on the FAFSA. Families in this situation think it's nasty, that asks students, they're just like when they ask parents about they ask about their taxed income, and then they ask about forms of untaxed income that they might have had. For the students, and on the list of untaxed income they might have received, they ask about gifts they may have received or bills paid on their behalf by anyone other than their custodial parent. And just to make it clear, they actually kind of put in parentheses, so people don't miss it, something to the effect of, hey kid, this means your non-custodial parent. So they don't, it also could mean grandparents if they're contributing to college costs, things like that.
Wow.
So if the non-custodial parent gives the student money, and it does specify money from the non-custodial parent that is not court-ordered child support, specifically child support. If the non-custodial parent gives the student money or pays bills on their behalf, including the tuition bill, that money has to be reported there on the FAFSA and is counted as student untaxed income. Again, income up to $7,000 is protected, but if the non-custodial parent is paying, a $50,000 tuition bill, it all of a sudden looks like this student has lots and lots of untaxed income, and again, it gets that 50% assessment rate. If the non-custodial parent paid $50,000, the first $7,000 is protected. The other $43,000, they take 50% of it. Essentially, it reduces financial aid eligibility by over $20,000. So this can be a big problem for students, for families in this situation. And this is where the look back period is pretty critical, because essentially, give or take, because the calendar years don't exactly line up with the academic years, but if non-custodial parent pays the freshman year tuition bill, that will affect the student's junior year financial aid eligibility, because it's 2 years in the future. They pay the sophomore year tuition bill, it affects senior year financial aid eligibility. And then there are no more financial aid applications because the student's finishing school. So non-custodial parent could pay whatever they want to junior and senior years of college without it costing them any financial aid. So this is really critical to think about in terms of, deciding among the two parents, or writing into any agreements who's going to pay for what. The typical split, you would typically think, and you can tell me if this is the case in your work, you would divide college costs in half each year between the two parents. Each parent pays 50%. But those payments towards freshman and sophomore year by the non-custodial parent could cost the student tremendous amounts of financial aid eligibility. So for financial aid purposes only, really, because there's lots of reasons not to do this, but for financial aid purposes, if you were going to split the cost of college, you would want the custodial parent to pay for the first 2 years, the non-custodial parent to pay for the last 2 years. That would be optimal for financial aid purposes. But of course, that's risky, really kind of both ways. And I think the biggest things I can think of is, number one, tuition tends to go up every year. So that would put the non-custodial parent on the hook for more money than the custodial parent, unless something is written in, to account for tuition inflation. And then the other big risk, I think, is for the custodial parent. They pay entirely for year one of college, and then the student drops out of college, which happens a lot. Now, the custodial parent is the only one who has paid, and the non-custodial parent never has to pay anything. So there's certainly reasons not to structure things that way, but for financial aid purposes, that would be optimal.
Right. Wow. Well, I see a lot of possible strategies and also a lot of potential traps for the unwary. So people are wise to spend some time thinking about this and talking about it. I imagine everybody's situation is a little bit different.
Correct. And I know we always say in the college admissions and college finance world, the answer to almost every question is it depends, because it really depends on the student. And I'm sure that applies to family law too, right?
Lawyers like to say that too, yes.
Yes. Yeah, so really every student is different, every family is different, every financial situation is different depending on the student and what colleges they're applying to and what everybody's income is, and if there are step parents involved, it really does depend. So it is always good to talk to somebody like this and make sure you're thinking about these issues and confer with an expert if you need help working through these scenarios.
Right. One last point that I don't think we've touched on are the tax benefits that might be available to families for paying for college. Can you touch on those for just a moment?
Yeah, so the biggest tax benefit, the most lucrative one for most families is called the American Opportunity Tax Credit, that you can claim if you are paying eligible college costs for an eligible child. For the American Opportunity Credit, you have to be considered a traditional college student in their first 4 years of at least half-time attendance. There's another tax credit called the Lifetime Learning Credit, which is tends to be American Opportunity Credit tends to be more beneficial. It's more money. But if you don't qualify for that based on the student status, if they're a grad student, if they're a fifth-year undergrad beyond those first 4 years, if they're only attending part-time, another credit is called the Lifetime Learning Credit, which gets you less money, but it's eligible. More students, kind of more expansive list of students are eligible for that particular tax credit. But I think the biggest thing for divorcing families, what they need to know about these education tax credits is that whoever claims the student as a dependent, they get to take the tax break. They get to take the tax credit regardless of who pays the tuition bill. So dad could pay the tuition bill, but if mom claims the student as a dependent on their tax return, it's mom who gets to take the tax credit, even if dad paid 100% of the tuition bill. So that's something that I would expect that families would want to address when they're writing up their agreements. Who gets to claim that student as an exemption on their tax return?
Yes, I can imagine clients being pretty unhappy if their lawyer hasn't quite paid attention to that one.
Yes.
Okay, well, you have so much information, and I'm so grateful for you for sharing some of it. And for people that might have more questions, I guess I can direct them to the Bright Horizons website for some more information about college financial aid planning or how to reach someone who can help you. And of course, I'm always willing to help anyone who might have questions about their situation in the probate and family court. So,
Perfect.
Shannon.
And yeah, just to put it out there, the direct website for Bright Horizons College Coach, the college counseling part of Bright Horizons, is www.getintocollege.com. If you go to brighthorizons.com, you can find us, but you have to dig a little bit deeper. If you go to getintocollege.com, that will get you right to us.
Great. Thank you so much for sharing that. And thanks again for being here with me today.
You're so welcome.